I am now going to turn it over to our hosts for today. This is Courtney and Sean over from GRS Community Management. Take it away, my friends.
Thank you so much, Jeff. Hi, my name is Courtney Buchan, and I'm here with Sean Thompson. We are the corporate trainers over at GRS Community Management. Our management offices are located in Lake Worth. We also have offices on the West Coast in Naples. We have a new office in Broward, and we have a Jupiter office as well. We've been providing great, reliable service since 1989. We're so happy to be here. Big thank you to Jeff Solomon for organizing this event, and a big thank you to all the attorneys at K. Bender Rembaum. They do the most for board education and community association manager education that I've ever seen. We have Alan, one of their distinguished attorneys, with us today, one of my personal favorites because he keeps it fun and light during the presentation, which we love. So that's all I have to say. I'm going to shoot over to Sean.
Hi, everybody. Thank you for joining us. Please check us out if you get an opportunity at grsmgt.com.
Thank you.
Thank you.
We'll turn it over to Alan.
All right. Thank you all. Well, thank you to GRS for hosting with us today. Thank you to Jeff for the intro. For those that don't know me, my name is Alan Schwartzide. I'm the managing partner of our Winter Springs, Orlando office of K. Bender Rembaum. 27 attorneys total, 4 offices. 9 of us are board certified specialists, including me in this area of law, 1 board certified in construction. So pretty much anything that your community could need, we've got you covered on the legal end. The offices that we have are located here in Winter Springs. We've also got Palm Beach Gardens, Pompano, which is our main office, as well as Tampa. Pretty much anywhere in the state, any issue that your community might be facing, we've probably handled it 100 times before. If you're happy with your attorney, fantastic. Stick with them. If you need a second opinion or you're not happy with your attorney, my email is right up there on your screen, as@kbrlegal.com. I'm going to go ahead and share if I can find it here. There we go.
Yeah, Zoom change. And folks, you don't need to let us know that you're here. The registration links that you receive, the join links you received after registering is tied in with your registration information. So when you click that link to join or enter your unique meeting ID code and that it gives you, everybody's got a different one. We know it's you. You don't have to go into the chat and say Joe is here or into the Q&A and say, can you see me? You're here. Everything's good to go. Alan, just make sure you didn't come in with somebody else's link, that you did it all on your own, and you're here with your own link and your own registration. Alan, back to you. Sorry for the interruption.
Thanks, Jeff. And to be fair to everyone who did that, we say that during every single class, and inevitably we get at least 5-10 people out of, looks like we have a little over 320, 330 on right now. So don't feel too bad if you did it. All right, moving on to the content of today's presentation. I'm going to skip through some of the information that I already went through, but you're welcome after you fill out your surveys. At the end of the presentation, when you get a copy of these slides, you're welcome to take a look at everything about me and about the firm. First set of statutes that changed. Now, keep in mind, we're talking about statutory changes from July 1st, 2025. Okay, there weren't really many changes. We'll see what DBPR wants us to actually teach about this year's statutes. But what we're talking about today is what's been already in effect for a year, which is one of the reasons that Jeff mentioned. This is kind of the procrastinators class because this stuff's been in place for a while. So hopefully you're already aware of it. But you know what? Hopefully at the same time, you learn something new about the laws that you already knew about. So this first set pertains to community association managers and management firms. We're not talking about just the HOA or condo laws. This is managers managing any condo, HOA, or co-op throughout the state of Florida. New penalties for license revocations. If a CAM has their license revoked, they cannot be an employee or work with in any capacity any management firm for 10 years. What that means is you get your license revoked, you got to leave management altogether. Now, that doesn't mean you can't work with another vendor in the same industry, but you will no longer be working with a management firm. So my suggestion, don't let that happen. It takes a lot and really intentional or super negligent actions to get your license revoked. Just don't do it. And then you won't have to worry about this. Creating and maintaining an account with DBPR, every CAM and every management firm has been required since July 1st to maintain and create an account with DBPR. This is done online on DBPR's website. Managers need to identify who they work with and identify what associations they are the designated on-site CAM for. Now, this is interesting because it specifically says on-site in the statute. So it doesn't really say that you need to do this if you are not on site. Managers and potentially management firms need to update this information within 30 days after it changes. Not really clear what the penalty is if you don't, but I would suggest doing it anyway. Management firms need to identify who they actually employ as a CAM. And if that license is suspended, the DBPR notifies both the management firm and the CAM that that license was suspended and presumably that that license cannot be renewed for 10 years and that they need to basically fire this person. Professional standards and contracts. You can't knowingly perform as a CAM or a management firm anything directed by the association, meaning even if the board tells you to do it, you can't do it if that act violates any state or federal law. Now, what's interesting is state law requires that you follow the declaration, the bylaws, and the articles as well. So it's not just violating laws, but doing anything that is improper under the governing documents or the Florida statutes or any federal law technically is a violation of the statute. So bottom line, you need to be very careful here if you're a CAM. And Condo and HOA directors, if your CAM says no, it's time to reach out to your attorney to find out whether they think this is a violation of any of these things. Because it may not be that the CAM doesn't want to do their job. It may be that they're refusing to violate this provision. If a CAM or a management firm has a contract with an association subject to milestone inspections or CEUs requirements, the manager or management firm is obligated to comply with those requirements as directed by the board. Now, keep in mind two things. We'll get to these milestone and CEUs reports later. It's the board's obligation to make all the reports that we got this thing. It's a breach of fiduciary duty of the directors if you don't do it. So I'm not really sure what the CAM is required to do other than go ahead and move forward and get it done. And then direct the board to or the officers to fill out this documentation that they're required to fill out that we'll talk about later. Another thing, each contract between the association and a management firm or a CAM directly needs to include this specific statement that basically says the manager is obligated to comply with all requirements of Chapter 468 of the Florida statutes. Chapter 468 may be one you've never heard of if you're not a CAM. It's essentially the one that governs businesses, certain businesses in Florida, including managers and management firms. So it's basically saying I acknowledge in the contract that I'm obligated to comply with these professional standards. So it's not only that the manager gets in trouble with the state if they fail to follow those standards, it's technically also now a breach of contract. The contract between the CAM and the association can't waive or limit professional practice standards. What you need to keep in mind is this doesn't say that they can't have the typical, we're not responsible for our own negligence, gross negligence, blah, blah, blah. It just needs to not disclaim any liability for violating these particular requirements. This one used to apply to only HOAs. Now it applies to all community associations. You basically have your office hours on the website. You need to attend at least one member or board meeting per year. Notice what this doesn't say. It doesn't say you have to attend that meeting in person. So if you're on the phone or on Zoom or Teams for any board meeting, technically you've complied with this obligation. One member meeting, you've complied with the obligation. And how many people don't have their manager handling or at least attending the annual meeting and the election? So my guess is that's where you're taking care of this. You also need to provide the members and post on the website the name and contact information of the manager, the hours of availability, and summary of duties. Again, you're giving your office hours on the website and post it. And then provide a copy of the contract between the association and management upon request of any member. What I suggest is if you're a portfolio cam, you just have a folder on your desktop that includes all of the contracts with communities that you manage. And that way, all you got to do is attach it to the email, drag over, and move on with your day. Because keep in mind, that's one you need to provide not as a record inspection, but immediately upon request. So just make it available. It shouldn't be that difficult. Just drag, drop into Outlook, and move on with your day. Conflicts of interest. We see this a lot this year. We see it with management firms. We see it with milestone inspection, the people that are performing them and people that are performing CEUs. So we're starting with management companies. Honestly, most of this is exactly what an officer or director would be obligated to do. If you're proposing to enter into a contract with the association that is for something other than association management, there's a rebuttable presumption that that's a conflict of interest. And let's be realistic. There's not just a rebuttable presumption. That's a conflict. Okay. If you're performing other services and you're the one putting this in front of the board, and especially if you're not providing alternative bids, yeah, there's a conflict in you giving your own services as the option. Okay. I'm not saying that's bad. Chances are most management firms are going to give a much better deal than a lot of the vendors that are out there. Just understand that it now needs to be disclosed. It considers a bid of 2,500, I'm sorry, more than $2,500 for anything that management is offering except management services, then you need to solicit multiple bids. Okay, that doesn't apply if it's disclosed in the management contract as a conflict. So what I'd suggest is that all management firms that offer other services just attach an contract that identifies all other services that are not management that are offered by the management firm or its affiliates. And that way you don't have to get other bids if you don't want to. This should not be up to the management firm as to whether you get these other bids. It should be up to the board, but that's one that I'll leave up to each individual board of directors. Moving on, the board meeting notice of a conflict contract with management needs to include a description of what's going to happen, what's going to be proposed as an activity, the possible conflict of interest, and a copy of those contracts, just like you would do for the board if they had a conflict. If that disclosure is not made that there is a conflict, then the contract is voidable. And just like anything else where that conflict wasn't disclosed, the termination fee is limited to the services or goods provided through the date of termination, not through the end of that contract. So this is exactly the same, like I said, as a board of directors having a conflict. Moving on, structural inspections. We're talking about MERS and CERS, all our favorite things.
Alan, I'm going to interrupt just for a second, okay?
Milestones.
I need to
Sure.
interrupt. Folks, I got a few questions now from people that might be a little bit late. We offer a slight grace period after the first slide, but I cannot see how late you got here until after the webinar is over. In addition, I'm going to repeat what I said earlier that we've all said a couple of times. This class, okay, is for board members of a condominium association, the CEU for board members of a condominium governed by 718. If you are with an HOA or a board member of a cooperative, you're welcome to listen and learn about them, but this is not going to get you a CEU, okay? So again, please, especially today, listen up to what we are saying because the deadline is tomorrow, and we have a lot of people here. Alan, back to you.
Yeah, I will point out if you're a board member of an HOA and you're thinking that this is going to get you one of your 4 or 8 credits, you might want to just see if you can take someone else's class. And I rarely recommend that. But honestly, with the deadline looming literally tomorrow to complete those 4 to 8 hours, This isn't going to get it for you. So just, trying to help. You're welcome to stick around. We're happy to have everyone. We've got roughly 350 people on today. I'm very pleased by that. But if you need to drop off because this is not the right class for your community, see you later. No worries. Hopefully, we'll see you for the next one. That is HOA specific. All right, back to the materials. Milestone inspections. That's your MERS. They now apply to buildings with a residential condo component with at least 3 habitable stories, as determined by the Florida Building Code. So that's habitable is the word that was added both to the milestone inspections and structural integrity reserve studies, which I'll call SIRS just for ease of saying it, because I don't like to add words where we don't need them. Now, when we say habitable, this bottom floor is probably not habitable for the most part. It looks like it's office space. Part of it might be, but for sure, this top floor that doesn't even have windows closed off, doesn't have walls closed off, is not going to count towards that 3 stories. So the top floor, I can almost definitively say won't count. The bottom floor might, and that will determine whether or not you need your milestone inspection. Are the stories that we're talking about habitable? So this is clearly at least 3 stories because you've got the windows, the balconies, and everything else on these 3 stories. So this building in particular would need a milestone inspection and a SIRS at some point. Now, I'm going to skip some of this because, frankly, some of the information that we're required to include you can get from the slides, but it's not going to impact directly the managers or the condo directors that are here. So that was another 15, 30 seconds to say I'm not going to waste your time with the rest of it. Now, the licensed architect or engineer who does bid to perform the milestone inspection, this is another conflict thing, must disclose in writing that they intend to bid on the actual work that's going to be performed as a result of that milestone inspection. The same now applies to SIRS. Okay, I'm saying this now so we can skip it later. This is a conflict disclosure. Okay, that's supposed to be in something that the person performing the milestone inspection discloses at the time of contracting. Now, the question I've gotten is, what if we already had a contract as of July 1st, 2025? My perspective is you can probably, based on the date of that contract, add an addendum, and I'm not going to get into Kaufman and all the other issues, but this would be a retroactive application of a statute to an existing contract. If the legislature or the judiciary were to say, you were required to comply with this, even though the statute didn't exist at the time you entered a contract. So my perspective is you add an addendum that says we're disclosing whether we intend to bid on the substantive work that results from this phase 1 and or phase 2 milestone inspection. If you're contracting now and you want to do the work as an architect, engineer, or group working under them, that's got to be in your underlying contract, or at least some disclosure needs to be made. And I don't see a reason not to put it in the contract because then it's your standard form rather than trying to prove that you actually made that disclosure after the fact. Again, contract is voidable if that disclosure is not made and you do propose to enter into the actual substantive work contract after the milestone inspection is completed. Now, for those that don't know, I'll briefly go through what a milestone inspection is. You're doing a visual inspection of the buildings to see whether or not there's any structural deterioration. And actually, it's substantial structural deterioration is the legal term. If there's nothing that you see in that initial visual inspection, you're done with the milestone inspection. You issue your report, you walk away. If there's anything that is seen during that inspection, then you move on to phase 2, which might or might not include destructive testing. It's going to be more invasive, so to speak. Okay. If there's anything found that needs to be done, that work that results from that milestone inspection is what we're talking about here now. Local enforcement agencies are responsible for milestone inspections being completed. We're going to skip this because this is just the form that you'll get from the local enforcement agency. All right, moving on. Video conferences. This is the general condo information. Okay, the term video conference was defined. We figured out that the notice for any meeting that's going to be held by video conference needs to include a hyperlink and call-in number for unit owners to attend. There also needs to be a physical location where unit owners can attend, and all meetings conducted by video conference now need to be recorded. That recording is an official record for 1 year, 12 months after its recording. Now, the thing to keep in mind is we're talking here about meetings. The statute says meetings conducted by video conference. My perspective until this loophole is filled, which was not done this year in this year's legislative session for the statutes that take effect 2 days from now, until the loophole is fixed. If you hold a meeting in person but offer a virtual option instead of reporting that the meeting is being held virtually, I don't see where in the statute it would say that you actually need to comply with any of these restrictions and requirements. Now, that is my legal opinion. It's a loophole, a creative solution to a non-problem that the legislature created. But if you want to make things easier and take a slight risk, in my opinion, you can do it that way by saying the meeting's being held in person. We're allowing people that want to attend virtually. Now, keep in mind, if you're talking about a meeting where the members get to vote, that will need to be addressed by the electronic voting that we'll discuss later on. If an association contracts with the management firm, all applicable licenses need to be attained, meaning you can't contract with a management firm that's not licensed. Shocker. Why the legislature felt the need to add this, I don't know. But the part that they did add that's substantive is all officers and directors of an association that signs a management contract bear an obligation to ensure that that management firm is properly licensed before entering into a contract. Now, what I would suggest, because in reality, directors and officers are not going to go researching DBPR, they're going to make the management firm provide this information. What I would suggest is whatever proof you can get from DBPR, whether that's a certificate of good standing that's good through a certain date, or just a printout from the DBPR website, just attach it to the contract or at least to the proposal package so that the officers and directors aren't having to go out and search this information out. If a contract's between a manager and the association and the manager is suspended, the association can terminate that contract by written notice with that termination effective on the date the CAM became unlicensed. That makes sense because if you're not allowed to work with an unlicensed CAM and they no longer have their license or their license is suspended, then you can't work with them. So why would you be obligated to continue paying them for work that they're not allowed to do anymore? Same thing with a management firm. Okay. I know that is not great news to the managers in the room, but that's just the way that this legislature put this into effect in the statute. Every condo needs adequate insurance, regardless of what the declaration says as to what you need to cover. You're going to cover, it just says adequate property insurance. The amount of that is for full insurable value, replacement cost, or similar coverage. And this may be based on replacement costs of the property to be insured as determined by an independent appraisal that needs to be done every 3 years. The obligation to obtain and provide adequate insurance of at least 3 communities may be satisfied by doing things that, frankly, I've never seen a community succeed in doing. So just contact your insurance agent and pay for your own insurance. Official records, there were a bunch of things added, but in reality, they were already official records because of the catch-all provision of that statute. So we can skip through this a little bit. If you willfully, knowingly, or intentionally violate the official records inspection statute, meaning you are not providing records that you're obligated to provide to someone after receiving a records inspection request, there is no longer a requirement that that happen repeatedly in a 12-month period before it's punishable by a criminal act. So this is now, anytime it happens, it is a crime. It's a misdemeanor, but it is a crime. In addition to maintaining adequate copies of the governing documents and your Q&A sheet on property, you now also need to maintain the most recent annual financial statement and the annual budget. Why you need physical copies of these things when they're on the website, I don't know, but you're required to keep them on property. Maybe it's so that people that are buying in or tenants in the property get access to some of this information. Moving on, official records. Your website needs to include the approved minutes of all board meetings over the last 12 months and copies of all affidavits required by Chapter 718. Changes effective January 1st, 2026. It used to be I'm not going to bother going through what it used to be because that was 7 months ago now. But any condo with 25 or more units now needs to have a website and needs to comply with all statutory website requirements. Understand if you've got a manager, your management portal, 99.9% of the ones I've ever seen will fully cover this, and GRS's portal does. If any of this information changes or you get new documents that need to be on your website, you have 30 days to upload them. Not having them on the website does not preclude you from doing anything. So there's really no penalty for not having them other than potentially being ordered to upload the documents to the website. Financial reporting, you used to have 120 days. You now have 180 days after the end of the fiscal year to get this done if you are sending it out to a CPA or other professional to get your financial reports prepared. Evidence of compliance with the delivery requirement, meaning you sent it out, the actual financial statement, or you sent something saying the financials are available to every member. That compliance affidavit needs to be made by an officer or director. Now, this is done in a couple places throughout the Florida statutes governing condos this year. It's here. It's also regarding milestone inspections being sent out and CEUs being sent out. I don't understand why that's done, and manager is not on that list, but that is what the statute says as of right now. So your manager signing that affidavit saying, I sent it out, is no longer good enough. Apparently, what you need to do is when the manager's doing that part of their job, you need to sit with them and watch them put all these things in the mailbox because somehow you're required to sign an affidavit saying that this was done. Now, my perspective is this affidavit can be based on business records, just like those records would be admissible as overriding hearsay in court. Maybe that's the way around it is. The manager sends it out, it gets put in the official records that it was sent out, and the officer or director signs an affidavit saying the records show that it was sent to these addresses in this way. I don't like that option, but it's the only other way around it that I can think of, especially for management firms who outsource their mailing to someone else and don't physically print out every single document, put a stamp on it themselves, and put it in their mailbox to go out the next day or that day. Now, if a majority of all voting interests vote in favor of it, you can reduce or increase your financial reporting level. This used to be a majority of the people that showed up when you had a quorum. It's now a majority of all of your members to increase or decrease your financial reporting requirement, let's say from an audit to a compiled financial statement, just so that we know what we're talking about here. Shocker, the board, in fulfilling its duty to manage operating and reserve funds of the association, needs to use best efforts to make prudent investment decisions that carefully consider risk and return in the effort to maximize returns on the invested funds. That was already the fiduciary duty. Why the statute needs to say it, I don't know. I guess someone was doing this wrong and some legislator got angry. I don't know why this needed to go in. The association can invest reserve funds in CDs, depository accounts at a community bank, savings bank, commercial bank, savings and loan, or credit union, and that does not require a unit owner vote. That is a board decision how and where to invest these reserve funds. Board meetings can be conducted in person or by video conference. Again, if the statute says you can do it either way, that's where we get back to what I said earlier about, well, this meeting's being conducted in person and we're giving a Zoom option. The division must adopt rules governing the requirements for board meetings. We were discussing right before we opened it up to everyone that the DBPR 1 year later has not done so. So what I had suggested to them was get 4 or 5 attorneys that are well versed in this area of law to put something together, and then you can adjust it, modify it, or approve it. Hasn't been done, and that request was rejected. Anyway, so as of right now, we've got no rules regulating that. Hopefully, they will be adopted soon. For video conferences, we already addressed this. They need to be recorded. That official record stays in for a year. Now, when I say the official recording of the video meeting, we're not talking about literally hosting the video on your servers. We're saying the Zoom or Teams recording link goes into a document on your notices page on your website. And that is good enough to have it hosted on the website. You just delete it after a year from that physical, either Word document or PDF or however you're storing it. Unit owner meetings now need to be held within 15 miles of the community or the same county. It used to be 45 miles. So understand you might want to reevaluate where you're holding your meetings if it's not at the community or within the same county. If it's at the community or in the county, you don't need to worry about the distance requirement. But if you're holding it, for example, at a school, a church, some other location, you need to be within 15 miles of the community or within the county. You can hold all unit owner meetings by video conference if you want. Again, needs to be recorded. The notice needs to be specific to what's included. If the annual meeting is by video conference, this makes no sense to me. A quorum of the board needs to be physically present at the physical location where unit owners can attend. So not only are we holding it by video conference, but we need to we need to hold it in person as well, just like all the other meetings we discussed. But now a quorum of the directors need to be present. So if we don't want to hold that meeting, apparently the legislature thinks it's a wise decision to say that if the directors choose not to attend, there can't be an election, there can't be an annual meeting, and they just stay on the board. Not the way I'd want it run, but that's what the legislature is allowing to happen. If a unit owner meeting is conducted by video conference, again, we record it. A unit owner can vote electronically in a very foolish manner, which we will touch on in a minute. Again, division's supposed to adopt rules, didn't. Broadcast notice is no longer good enough instead of physical posting. I don't know anyone that's still using CCTV broadcasts to notice their meetings, but you can still do it. It's just not a formal notice of the meeting. Budget meetings. That can be conducted by video conference. Again, division adopts rules that they haven't adopted yet. You need to use enough of a sound transmitting device so that everyone can hear what's going on and can speak. So it needs to be a decent computer and preferably a separate device, whether that's, the owl that I've seen in a couple places or something else, some kind of teleconferencing physical hardware, but you got to use something where everyone can hear, everyone can speak. Now, we made some changes, or the legislature made some changes to the 115% rule. It was never really understood well, but essentially, if you increase your budget compared to last year by more than 115%, excluding reserves, insurance premiums, and expenses that are not going to be recurring every year. So you're taking all of those out of the equation. If everything else, the things that you're actually paying every year that are not reserves or insurance, increase by over 115% compared to last year. It used to be that you would provide the opportunity, but members had to bring it to you to create an alternative budget. Now, instead of the members having to ask for one, the board actually is obligated to propose two different budgets if this statute applies to your budget. One of them is going to be what you want in there, the budget you'd already be preparing. The other one is supposed to be an alternative budget that eliminates any discretionary spending whatsoever. Now, I don't know any condo in Florida that includes anything that's discretionary in its budget. You put in your budget what you're going to be required to do, and you would be sued for breach of fiduciary duty if you didn't include it because you want to stay on the board and you don't want to have assessments to replace the pool furniture every single year. You want it to be what is necessary to maintain and operate the community. Okay, so I don't know what discretionary spending you'd really be taking out. You might end up with two identical budgets, but the members get to vote on that. Somehow they're supposed to vote at the budget meeting, which, by the way, is a board meeting. the members get to vote on which one of these. And if the members don't vote in a sufficient percentage to adopt the alternative budget, the board gets to adopt the original. Um, if a majority of the total members adopt it, so let's be realistic, how often do you get a majority of the total members to show up to a meeting in the first place? But they need to vote in favor of this alternative budget. Otherwise, the regular budget goes in. You do need to give 14 days notice and a copy of the budget itself, or a notice that it's available at least 14 days in advance of the budget meeting. Okay, that used to be in a condo and in an HOA. Yeah, but it's not a special assessment, so we don't need 14 days notice. Now you do need to do this if a substitute budget is going to be proposed, because you need to give the members time to actually evaluate the difference between one and the other and decide whether to show up. Um, yeah, we're not going to do alternative funding methods. That doesn't come up very often. Talk to your attorney if you're operating at least 25 condominiums. Reserves now need to include, it used to be anything maintenance expense. Now that's up to 25,000, and that'll be increased February 1st of every year after. So there was an increase to 25,675 this year. That's the current figure, and it'll increase again in February based on inflation. So understand you're not just unilaterally deciding on the increase, but as of now, anything that's not going to cost 25,675 and is not on the list of things that you're required to reserve for otherwise, you don't need a reserve. So again, this is up from the $10,000 that we had last year. Let's see. If you are condemned for reasons of needing to do work on your building, the structure of your building, and the building is no longer habitable, you can have the board, without a member vote, pause your reserves or reduce reserve funding so that you can fund the work that needs to be done. The reserve accounts can be pooled for one or two more required components, but keep in mind you need to keep the structural reserves separate from the pool of non-structural reserves. So you can't just shove everything together, because then you might be using the funds from from the structural reserves for non-structural items, which is a no-no in general. You can't use them for any other purpose. So again, you can pool both. You can pool one or the other. You just can't have one pool for all of those or any category of non-structural in the structural pool, and vice versa. You don't need a member vote. The board gets to vote to switch from pooled to straight line reserves. The question is what you do with the money, because you can switch the type of reserve, but you can't pull the money out of a straight line into the pool, in my opinion, without that member vote. So you might just use the money up that's in that pool, in that straight line reserve when it's needed, and then just start funding the other reserve separately. Let's see. Members can vote to waive maintenance of reserves recommended by the most recent CEUs if you are terminating after the member vote to terminate. Because why would these members have to put money away for something that by the time it gets damaged or needs replacement or repairs, they're not going to own their property anymore? CEUs reserves can be funded by regular assessments, special assessments, lines of credit, or loans. But the legislature decided that regardless of what the governing documents say, they're going to now impede your ability and say you need to get a member vote, even if the board could otherwise vote on it, to do anything other than regular assessments to fund your structural integrity reserves. I don't understand that one at all, but it's the way that the legislature did this. And they didn't fix it this year, even though we pointed out that it makes no sense to make it harder to fund your reserves. I guess they didn't want them funded through these other sources, but they're saying, listen, if you can get a member vote, have at it. The unit owner controlled that needs the CEUs may secure a line of credit or loan to fund capital expenses required by a milestone inspection or CEUs, but not a developer controlled association. The line of credit or loan needs to be sufficient to fund everything that you haven't already funded. So this is where you're doing the work, you're bouncing back into funding everything and fully funding what you weren't doing while the work was going on, because you got that vote to approve. not funding the reserves for a short amount of time, up to 2 consecutive fiscal years. And now you're making funding immediately available through that loan or line of credit for anything that you might need in the future. Again, need a member vote, need to have the ability to pull the funds out immediately if you're going to use a loan or line of credit rather than a special assessment or regular assessments to fund your reserves, at least your CERS reserves. Now, the statute doesn't necessarily say that about funding non-CERS reserves. So what you might want to do is have the CERS reserves in your maintenance assessments and the non-structural ones vote to go ahead and go out and get this, the loans or special assessments and do it that way so that you don't need that member vote unless your governing documents say you do. For a budget adopted on or before December 31st, 2028, if you finished a milestone inspection in the last 2 calendar years, the majority of all voting interests can pause for no more than 2 consecutive annual budgets, like I said, your reserves so that you can get the work done. Again, doesn't apply to developer-controlled associations. Once you pause that, you need a new CERS after the work is done so that you know what you should be putting away now that you've got that work done and you've got an updated valuation of what these things are. You've got an updated timeline for when it needs to be replaced, repaired, maintained, etc. So you're going to get a new CERS. Now, what you might want to do instead of getting a whole new report is have your contract with whoever is providing your CERS state that they're willing to do updates at a discounted rate or do partial updates for less than the full cost. Again, habitable stories, $25,000 we discussed, so we're going to skip this. The CERS must be performed, including the visual inspection, by a licensed engineer, a licensed architect, or someone who's certified as a reserve analyst. At minimum, it needs to include recommendations for reserve funding schedules based on what we call a baseline funding plan, which basically means none of your reserves ever go below 0. The CERS can recommend other types of reserve funding schedules if each recommended schedule meets the association's maintenance obligations. So it doesn't need to be necessarily that you just take the time, you cut it by the amount of the dollar figure, and you get your per year CERS responsibilities. It can be done in different ways so that it's not all loaded the same way across that timeline. If the CERS recommends reserves for anything that's not a CERS component, that amount of the recommended reserves for that item needs to be separately identified so you can figure out what you're obligated to do, what you're not allowed to even have a member vote to either reduce, remove, waive for the year, or use for another purpose, versus what you can do those things for. The funding method needs to be considered in the CERS. If it's performed before the association approves a special assessment, it needs to be updated again to reflect how you're going to fund that the CERS and actually the reserves themselves. So your structural reserves, not the report. The CERS can be updated to reflect any changes to useful life or valuations after you do the work or after you find out that the valuation's different. The effect that that repair or replacement has on the reserve funding schedule. You do need an updated CERS before adopting a budget where the reserve funding from all of these sources doesn't align with the funding plan for the most recent version of the CERS. What does this mean in English? You can't just ignore the CERS because you think you know more because you have new facts. You need an updated report. You need to follow what's in that report. You cannot just do what you think is right. You have a legal obligation to follow what's in the CERS. So make sure that whoever's preparing it for you is someone you trust to keep your best interest in mind. CERS isn't required for 4 family dwellings with 3 or fewer habitable stories above ground. Used to be up to 3. Timeline-wise, we got an extension to December 31st, 2025 for associations that existed before July 1st, 2022. Obviously, that's now already passed. If you did a milestone inspection or something similar that covers all the milestone inspection requirements, the association can delay the CERS for no more than the 2 consecutive budget years so that you can get the work done. An officer or director must sign the affidavit, again, not the CAM, saying that the CERS was received. This one, yeah, it makes sense that you can sign that because you got it. And the division must adopt a rule, the form of the CEUs, which they have not done yet. Okay, we talked about the milestone inspections and the conflicts. It works the same if you want to perform a CERS. Contract's voidable if you don't disclose that you want to do the work, in addition to saying what work needs to be done and when. Hurricane protection, unless the governing documents say otherwise, and specifically the declaration, unit owners don't pay for the cost of removing and reinstalling hurricane protection. If the removal is necessary for for doing a task that the association was already obligated to do. So when you're removing the windows and replacing them, someone who had hurricane shutters that need to be taken down and put back up so that you can do that work does not pay for the cost of doing it unless the declaration says so. So this might be an amendment to consider if you've got a lot of members that have hurricane shutters, but not all of them do, so that the people with hurricane shutters get a benefit that everyone else doesn't. The board needs to determine whether removal and reinstallation needs to be completed by the unit owner or the association if the declaration doesn't specify. Okay, so if you don't have anything in the declaration, you tell the unit owners they're responsible, and that's okay. But that doesn't mean they're responsible for the cost. My suggestion is the association should really be taking that on because I really don't want people digging into the outside of the buildings if I don't have to allow it. If the association vendor and not the owner's vendors, who could be anyone that they choose, is doing this work. All right, we have more hurricanes. If an evacuation order goes out in the location where the condo is located, the board can say everyone needs to get the hell out of Dodge. And if anyone decides to stick around after that order goes out, the association's not responsible for any injury or any damage to their property. What I would suggest, and this is now, I used to say there are 7 categories that I think everyone should have a policy on. A disaster plan, I don't know why I didn't think of it earlier, but a disaster plan that includes sending out these notices now that the statute allows for it is something I think every community should have. It's what contractors do we know will be accessible, that we work well with and that we like and that we trust? Do we have a form addendum if we don't have our contractors able to come out that our attorney prepared for us so that we can attach it to these BS estimates that all of these people from out of state come in when there's a storm and say, I can clean up all of this stuff and I'll charge you a little bit more because it's an emergency, but I'll take care of it. Okay, there's a company locally that says the warranty on that work and the guarantee that they did it right without causing any more damage is a tail light warranty. That means when the tail lights are gone, so's the warranty. Okay, my perspective is if you get an addendum from your attorney, it may not protect against every potential problem, but at least for the $3,000 to $5,000 that they might charge to prepare that one time, then when you have these emergencies come up, you've already got the document, and all you need to do is fill out the details of the contract, and it's going to protect you in instances where there's no attorney's fee provision if you have to sue this vendor for causing a bunch of damage, or where they just don't do the work and they take your money and run. Okay, all of these things are things that your attorney can protect you against if you have them actually prepare something for you. Electronic ballot voting. So this is one of the worst things that I think the legislature has done is these electronic ballots. But electronic voting, you don't need a 14-day notice. This is your typical 48 hours to adopt electronic voting. If at least 25% of the voting interests of the condo ask for a resolution for electronic voting for the next election, the board needs to hold a meeting within 21 days after receiving it, as long as the petition's received within 6 months after the last annual meeting. My perspective, because of what was put into the legislation of 2025, every single condo in Florida has almost a legal obligation to adopt electronic voting. Here's the reason. If you don't, you have to use these electronic ballots instead. Okay, you don't have to adopt the electronic balloting if you have electronic voting. The electronic balloting is problematic for a couple of reasons. The way that you're doing it is, one, you have to create a completely new email address you never had to have before that's specifically for purposes of submitting ballots by the members. You are creating a separate ballot from the one that you're going to give to everyone for electronic voting only. It needs to contain a signature block where the signature is just the owner typing their name or someone typing the owner's name and submitting it. You do not verify that it came from the correct email address. You do not verify that it's actually the owner submitting it. You are required to just accept what comes in. So two things can happen here. Okay. Yeah, you have the owner type their first and last name. Anyone can do that. That functions as the signature. You can't really question it. You need a space for the unit number. Okay, not different from any other ballot that they would submit. That outer envelope contains that information. You also need a statement in capital letters and big font that says you're waiving anonymity by submitting this virtually and submitting it via email, which wouldn't happen if you were using electronic voting or submitting a ballot in the normal condo fashion. Now, the problem is if someone submits 50 ballots for a unit that's not even theirs, now none of those ballots count, including the person that actually voted via electronic voting or some other medium. They've basically wiped out that vote. Okay? It's election fraud, and technically it's a crime, and so people shouldn't do it, but people perform crimes a lot. And until they get caught, they can go through 5 different VPNs so you can't figure out who submitted it. They can, forge the email address of this owner. And again, you don't even need to check the email address. And frankly, you don't have the right to. So this is going to invalidate a lot of elections or at least election results. My recommendation is because if you use electronic voting, you're not required to do electronic balloting. Use electronic voting and then you don't have to worry about it. Let's see. Yeah. We're going to skip non-residential condos that are 10 or fewer units because I'm presuming no one's on there, but you can ask questions later if you want. Condos within a portion of a building or a multiple parcel building. This is where you've got your condo hotel, or like in downtown Orlando, there are areas where the bottom floor is is retail, and every floor above that is residential. For those types of condo buildings, within 60 days after the end of the fiscal year, the owner of the non-condo portion needs to provide a complete financial report of all costs for doing the things that they're responsible for doing that they charge the association for. That report needs to include copies of all receipts and invoices. If they don't do it, they can be penalized by DBPR and otherwise enforced and ensure compliance by DBPR. But if you don't challenge that within 60 days, keep in mind you've waived the right to challenge it altogether, just like an election dispute. And that challenge is governed by 720.311. It's just like every other condo dispute that goes to pre-suit mediation. That's why we're talking about, I know you're governed by 718, but that is the statute that 718.1255, the dispute statute, refers to when talking about mediation. DBPR is now authorized to regulate milestone inspections, milestone inspection repairs, requirements to maintain insurance or fidelity bonding, condo board member education requirements, like we discussed, and reporting requirements for CEUs. You do, as a condo, need to create an online account with a division. I'm going to presume, hopefully, everyone's done that. If you haven't, since you were required to do it by October 1st of 2025, which is now almost a year ago, hopefully you'll take care of it after this class. You need to update any information that's on that DBPR portal within 30 days after it changes. At least 45 days notice of any requirement to provide any information after the condo initially creates an online account comes from the DBPR. So if you haven't done this, DBPR is supposed to send you a notice saying you didn't do it or you didn't do it completely before you get any kind of penalty. Whether they'll do that, I don't know. I'm not going to go through the information that goes on there because hopefully you can all read. All right, My Safe Florida, I think, is the last condo specific one we've got here, and then I'll shut up for a minute and let Jeff jump in right around on time. This is a great program for condos. It's essentially a way of getting government funding to shore up your buildings for hurricane protection. It's a $1 spent by the association to $2 spent by the state government. These funds disappear roughly a week after the program opens up every year. So when it opens up, if it opens up again this year, I would make sure that you get your member votes, get your application in, because this money disappears quickly. So there are two different reasons to ask for it. One is if you want to do a study of what could be done to shore up your building. Once you find out what that information is, the government can also partially fund the actual maintenance, repairs, replacement, whatever work you're doing to shore up your building in the event of a hurricane. It amends the definition of condo to exclude detached units on individual parcels of land this year. Prohibits you from applying for an inspection or grant unless you've complied with milestone inspection requirements and CEUs requirements, so that they're not giving money to people who still need to do these basic things. Prohibits the condo from applying unless the windows of the association are established as common elements. In other words, you can't have the government paying for things the members are required to maintain. Only 75% of unit owners rather than 100% vote needs to be approving the application for the grant. So it's a little easier to get this free money. Clarifies the matching, etc. All right. Timeshare plan management. Frankly, Jeff, if you don't mind, I know that it's another 2 minutes, but since I basically am skipping through most of this information, I'm just going to finish up the slides and then I'll let you go for it.
Sounds good.
All right, thank you. Um, Again, skipping timeshares, administrative procedures, unless you are in a state agency, this doesn't apply to you. Education and correctional facilities, unless you're in jail, this doesn't apply to you. Flood disclosures. This is if the association is renting or selling a property, you are adding a flood disclosure to any rental, purchase, etc., before the rental agreement or sales contract is finalized. So this is a disclosure if you are the one as the condo, not if you are the association and some owner is selling or renting their property, but if you happen to own the unit and you are renting or selling it, these disclosures need to be made. So it's regarding known flooding history, filed flood insurance claims, and assistance that was received for flood related issues. Now, I promised it would just be another minute. I'm sorry I went to 2. Jeff, come on back and do your thing, but thank you all for sticking around. We'll get to the Q&A in just a minute, but for those that want to jump off, I want to let Jeff give you the opportunity.
All right, folks. Thank you, Alan. Thank you, Courtney. Before
Thank you,
we do,
Alan.
Thank
yeah,
you.
thank you, thank you. So if you haven't already pressed the chat button, so it appears this is other than Alan's material that we just went over, this is the single most important thing you need to do to make sure you get your certificates emailed to you in a timely fashion. So please listen up. If you walked away for a moment, come on back and please listen up. In the chat area, we've already placed the link for the required post-webinar form for you to click, then fill out, and then submit. If you haven't yet pressed the chat button, you won't see that. So please press the chat button now so it appears. And I'll do it again in just a moment. I'll paste it in there. Once you see that, I want you to click on the link and go to the form on your browser. This is what will open up. This here, you're going to fill this all out. Anywhere you see an asterisk, it's a required field. This is very important too. I know it doesn't seem important, but it is. Please do not use all capital letters. Use traditional mixed case, upper lowercase. It's an automated process, and the font that is used is a script font. So if you do all capital letters, you won't be able to understand your name too well. So upper lowercase, traditional upper lowercase with your names. And normally I'll fix those, but with the deadline looming, priority is going to be given to everybody who follows directions today, okay? And then everybody else I'll get to afterwards. But so please follow the directions. And then the second most commonly made error for an unsuccessful submission, when you click the I'm not a robot box, wait until that circle stops spinning and you get the check mark, then hit submit. If you hit submit right after clicking the box and it's still spinning, it's not going to go through. And I see that happen quite often. And up here in your email address area, please make sure your email addresses match. If they don't, look for language underneath here. It's going to yell at you and say your email addresses do not match. I'll go over this again much more slowly afterwards. Now, after you submit your post webinar form, okay, your required part is over. You don't need to stay. I know that's going to come up a few times in 5 minutes. You're going to say, hey, do I still need to be here? Please, you do not need to stay. We want you to stay for the Q&A, but it's not required. You don't have to remain on for the Q&A after you submit the form. Alan, Courtney, back to you both.
All right, Q&A. So Glenn asks, I understand the pooled structural and non-structural reserves need to be separated. Is that an accounting exercise or a requirement to have two separate bank accounts? So we have fully funded pooled reserves, but happen to be in the same insured cash sweep money market account to keep all funds insured and collect reasonable interest. Well, the interest is going to be the same even if you swap and separate those out. And candidly, there's nothing that I'm aware of that specifies in the statute that it needs to be a separate account. It just needs to be accounted for completely separately. But from my perspective, commingling those funds means that they're available together, even if you're accounting for them separately. I always tell my clients that are asking this question, I would keep it completely separate rather than keeping the funds together if you've got the option without any major detriment. Let's see. James, is management required to get a fidelity bond? And is that a separate bond from what the board is required to get? Yes, because they're handling association funds. If they're not, then probably not. So that is generally going to be the same one that the board is required to get. So if management has it and it's part of the management contract that they're saying they already have it, you probably don't need a separate one. I would just make sure with your attorney based on what management is actually doing in practice and is obligated to do, whether or not you need to get a separate fidelity bond. Let's see. Samantha, I performed a search on our management company, and beside the CAM license, there's also an elevator license. Can you explain? I absolutely cannot, because I don't know why a management firm would ever have an elevator license unless they are operating a separate entity that also does that. And I don't even know any management firm that even wants to get into that arena. So candidly, no, I can't explain it. Sorry. Ginger, can condos invest in treasury bills without a member vote? Um, Technically, it's not a bank account and it's not a CD, so you might need a member vote on that one. I suspect not, but I would get a confirmation from your attorney before you do it because it's not named directly in the statute, even though it's one of the safest bets. Um, I would still get something in writing so that if someone says you did it wrong, at that point, you've got the defense that you relied on advice of experts. And while I may be qualified by the Florida Bar as an expert, I'm not your expert unless you are a client of mine. So sorry. Samantha, can you go back to the grant information? So this is presumably we're still talking, or we're back to talking about the My Safe Florida Condo program. Essentially, you go online, you get a member vote, the government gives you money if you are accepted. And again, that money disappears after like a week or two every year. But if the government says yes, then you can get money for either or both. Finding out what you can do to harden your building, so to speak, for hurricane protection, or actually doing the work. There's a lot of information, and I could probably do an entire class on that program. What I would suggest is get with your manager about whether they can help you apply for this program and get the member vote once it comes up again. If we're doing concrete restoration, Penny asks, supervised by an engineer, can it replace a milestone inspection once completed? Only if they provide a report that is the equivalent of your milestone inspection. An engineer that's supervising is authorized to perform a milestone inspection, but you're still going to need that report that would be the equivalent and contain all the information regarding that area that the milestone inspection would have included otherwise.
Alan, I need to interject because a lot of people are typing things into the chat that we've said a few times already. So please listen up. These slides can be downloaded and saved after you fill out the post-webinar form. Let's see what else here. There was another question that comes up, Alan, that came up in the Q&A a few times earlier about the CEUs not applying to three-story condos where each floor is one unit. Is it the same thing? Does three habitable stories mean three different units, or does it also count if it's one
So
apartment taking up three floors?
So there's a completely separate exception where if it's a one, two, three, or four family dwelling, it's not going to apply. That would be a three family dwelling.
Okay,
Even though it's a condo, even though it's 3 stories, it generally won't apply.
thank you.
Sure.
Back to you.
Uh, Andrea asks, can you please let us know what happens if one of the board members doesn't complete the CEU requirements by the deadline? Generally speaking, the statute's about as clear as mud. My perspective is it's the same as not taking your board certification class, and technically you should be suspended from serving on the board. The question is who's actually going to police that? We were talking about this earlier. Unless someone looks into it and reports you, who's going to know? DBPR is not necessarily actively monitoring this stuff because it only goes into the official records. If you're a CAM, that's a different story. But if you're on a condo or HOA board, I don't know. Probably nothing happens, to be candid, Andrea, unless someone cares enough to pull the official records and report this and say something. Brooke asks, when planning a budget, what do you do if there's a SERS done, but there was also a major hurricane damage and they're currently working on it? They need a new SERS because they've redone basically everything, but there are still more things they're finishing up and are planning to finish up in the next budget year and then do the SERS. Um, that is a pause in SERS funding due to the work that's being done. That would be something that I would get an opinion from your attorney again, not because I don't know the answer, but frankly, so that you're protected when someone says, why didn't you put this money away? Let's see. Jessica, can the owner of the management firm be licensed and could allow the managers unlicensed to conduct association business? The answer, in short, is not really, except to some extent. Managers that are not licensed are still allowed to perform what we call ministerial work. So your admin work. They're just not allowed to do the actual management. So they probably can't deal with, creating your budget, doing certain things, sending out demand letters, things of that nature. But they are allowed to basically be, I don't want to say secretary, but like the secretary you would see in an office. That's all they're allowed to do. But the actual management needs to be done by someone who is licensed individually. All right. Martha asks, is any of the material submitted to DBPR available to the public and board members see it? Anything you submit to DBPR is generally available to the public because it's a government database. I think DBPR was working on basically making it so that what you submit to them to register is not, but the reality is the whole point is so that the government knows who's in charge of this condo, what they're doing, who the managers work with and for. So I don't see it being pulled back from what we call a FOIA request. All right. Can a unit owner run for the board if they're delinquent but on a payment plan? That's going to be up to the board. The reason I say that is the fact that they're on a payment plan means they're not current. So technically they can't run. Now, if the board decides that being on a payment plan and being current on that payment plan is sufficient, that's up to you. So I would suggest that you make sure that, you're treating this equally across the board. Dominic asks, I'm sorry. Dominic asks, who's responsible for a plumbing pipe broken or cracks in unit under condo? That you have to read through your governing documents to figure out whether it's part of the common elements or part of the unit, part of limited common elements, and specifically what the declaration says as to who's responsible for maintaining, repairing, or replacing those items. So can't answer without looking at your documents is the answer. Glenn, I want to be sure I understand the restriction on adjustments to SERS without a Florida license, PE, or architect or person that is authorized to do a reserve study. We can increase estimated replacement costs if we think SERS estimate's too low based on a quote. Yes, that's true. Also, if we complete replacement of an item between professional SERS reports, are we allowed to show the item being completed in structural reserve, or do we need to provide evidence to a Florida licensed PE? That's going to be up to the individual person preparing your SERS report. If the person that's preparing it is good with relying on what you're telling them without doing an inspection to make sure that the work was done sufficiently, great. You might get that report back. If not, they'll probably want to come out to your property and take a look. All right. Well, that's all
Got
we've
them all.
got for now.
There was one question where I just finished typing for the person. She put it into the wrong section. I said to please put it into the Q&A. I'll just read it
Okay.
aloud.
Uh,
Jan, does the resolution for electronic voting require 14-day notice to owners?
not in a condo anymore. It's now 48 hours notice. That's one
Yep.
of the things we talked about changing this year.
And it
And
looks like,
Natalie added after I said we were done, if a board member's bringing in vendors as opposed to the CAM, is that considered a conflict of interest? Um, if the board member is bringing in vendors, is it a conflict? Oh, I think this pertains to whether the board member is bringing in conflicts of interest
like a family member
pertaining
who owns a
to
roofing
the
company, I think.
management firm itself. It's still a conflict regardless of who's bringing it in. It's still the management firm and an affiliated entity proposing to do the work, so you need to treat it as a conflict.
Okay.
All right. And that's the last question I see. I don't see anything more in the chat. So I'm
Nope.
going to presume we've covered everything that everyone needed handled. Thank you all for being here. Thanks again to Courtney and Sean and GRS. What do you guys have to add? Because all I'll say is if you need an attorney and you're not thrilled with whoever you're working with, or you need a second opinion, you know where to find me.
Mhm. Absolutely. Well done, Alan. Thank you.
Thank you, Alan. That was
Thanks.
amazing.